I stared at the $500 fine notice taped to my front door, my breath forming clouds in the frigid Massachusetts morning air, and felt my blood pressure spike in a way that had nothing to do with the cold. My name is Connor Stanton, and I had just become the latest victim of the Meadowbrook Heights Homeowners Association, led by their tyrannical president Patricia Harmon. The citation was printed on official HOA letterhead, complete with their ridiculous logo featuring a perfectly manicured lawn and a house that looked like it belonged in a suburban fever dream. The alleged violation: plowing snow from my driveway into the street during last week's blizzard. I ripped the notice off my door and stormed inside, tracking snow across my hardwood floors. My golden retriever, Murphy, looked up from his bed with concern, sensing my agitation. I ignored him and read the citation again, hoping I had misunderstood something in my initial rage-filled scan. Nope. It was exactly what I thought. According to Section 14.7 of the HOA bylaws, apparently revised just 2 months ago without proper notification to residents, homeowners were prohibited from depositing snow into the street. The fine was $500, due within 30 days, or it would increase to $750 with additional daily penalties. This was Massachusetts. We got snow, a lot of it. Where else was I supposed to put 15 inches of heavy, wet snow from my driveway? My yard was already piled high from previous storms. Every single neighbor on my street had done the exact same thing I did. But somehow, I was the only one with a citation fluttering against my door like a scarlet letter. I pulled out my phone and called my neighbor, David Martinez, who lived 3 houses down. "Did you get one?" I asked without preamble when he answered. "Get what?" David sounded confused. "A fine from the HOA for plowing snow into the street." "What? No, why would they fine us for that?" "Everyone does it. The town plows do it when they clear the roads." "Exactly my point," I said, looking out my window at the snow-covered street. "But apparently Patricia has decided it's against HOA rules now." David was silent for a moment. "That woman is insane. She tried to fine me last month because my trash cans were visible from the street on a non-collection day. They were in my garage with the door open while I was cleaning them out." "This is different, though," I said. "This is about basic property maintenance. Where am I supposed to put the snow?" "Want me to call Thomas? He's a lawyer." "Not yet. Let me do some research first. But yeah, we might need him." After hanging up with David, I sat down at my kitchen table with my laptop and started digging into Massachusetts state law regarding snow removal. Murphy wandered over and put his head on my knee, and I absently scratched behind his ears while I read. It took about 45 minutes of searching through state statutes and municipal codes, but I finally found what I was looking for. According to Massachusetts state law, specifically MGL Chapter 85 Section 7A, property owners were not only allowed to deposit snow from their property onto the adjacent street, but it was actually considered standard practice. The only restrictions were that you could not create a hazard or obstruction to traffic, and you could not deposit snow onto state highways without following proper procedures. Our street, Maple Grove Drive, was a residential road maintained by the town of Ashford. It was not a state highway. The State Department of Transportation had published guidelines that explicitly stated homeowners clearing private driveways and parking areas could place snow in the street as long as it did not create dangerous conditions. The town plows would then redistribute it or remove it during their regular operations. I felt vindication surge through me. The HOA was not just being unreasonable. They were trying to enforce a rule that directly contradicted state law. HOA bylaws could not supersede state statutes. This was going to be easier than I thought. I drafted a polite but firm email to Patricia Harmon, citing the relevant state law and requesting immediate withdrawal of the fine. I attached copies of the statute and the state DOT guidelines. I even included a link to the town of Ashford's own snow removal policy, which encouraged residents to clear their driveways and place the snow in the street for municipal removal. I hit send and felt pretty good about myself. Surely, when confronted with actual law, Patricia would back down. The woman was power-hungry and annoying, but she could not be stupid enough to fight state law. I was wrong. Her response came within 2 hours. It was 3 paragraphs of condescending explanation about how the HOA bylaws were contractual obligations that all residents agreed to when purchasing property in Meadowbrook Heights, and that these bylaws took precedence over general municipal guidelines. She claimed the state law I cited did not apply because it was permissive rather than mandatory, meaning the HOA could impose stricter standards. The fine would stand, and failure to pay would result in a lien on my property. I read her email twice, my jaw clenching tighter with each word. A lien. She was threatening to put a lien on my house over this nonsense. I called David back. "We need Thomas. Can you get his number?" 20 minutes later, I was on the phone with Thomas Brennan, who lived 2 streets over in our development and practiced real estate law in Boston. "Connor, I have been waiting for someone to challenge Patricia on something like this," Thomas said after I explained the situation. "She has been pushing boundaries for years, but everyone just pays the fines because they are afraid of retaliation or do not want the hassle. This is different, though. She is clearly wrong here. So what do I do? First, do not pay the fine. That would be seen as accepting their interpretation. Second, I will draft a letter on my firm's letterhead explaining why their fine is invalid and unenforceable. Third, if they do not back down, you will need to file a complaint with the state attorney general's office. HOAs in Massachusetts are subject to oversight, especially when they are violating state law." "Will that be expensive?" I asked. I was a software engineer working for a mid-sized tech company in Cambridge. I made decent money, but legal fees added up fast. "The initial letter is on me. Neighbor to neighbor. If it goes further, we will work something out. But honestly, I do not think it will. Once Patricia realizes you are serious and have actual legal backing, she will fold. She is a bully, and bullies back down when confronted." Thomas clearly did not know Patricia as well as he thought. His letter went out the next day via certified mail, email, and hand delivery. It was 4 pages of detailed legal analysis explaining why the HOA bylaw was invalid, unenforceable, and potentially opened the HOA board to personal liability for harassment. It demanded immediate withdrawal of the fine and a written apology. Patricia's response was to double the fine to $1,000 for what she called frivolous complaints and harassment of HOA board members. I stared at the new citation when it appeared on my door 3 days after Thomas's letter. This time, it was not just taped there. It was in a plastic sleeve that had been screwed into my door frame, leaving 2 small holes in the wood. She had damaged my property to deliver a citation for a violation I had not actually committed. The irony was almost funny. Almost. I took pictures of everything and forwarded them to Thomas. "Okay, now I am mad," Thomas said when he called me that evening. "She damaged your door to deliver an invalid fine. That's vandalism. We are going to the town, the state, and if necessary, the media." "The media?" That seemed extreme. Connor, think about it. Every homeowner in every HOA neighborhood in Massachusetts needs to know they can't be bullied like this. Patricia is not going to stop unless someone makes her. This is bigger than just you. He was right, but the idea of going public made me nervous. I was a private person. I did not want my face on the news or my story spread across social media. But the alternative was letting Patricia continue to abuse her tiny amount of power, and that felt worse. "Okay," I said. "What is the plan?" The plan started with filing a formal complaint with the Massachusetts Attorney General's Consumer Protection Division, which had jurisdiction over HOA disputes. Thomas drafted a detailed complaint outlining the invalid fine, the retaliation, and the property damage. We included all documentation: the original citation, Patricia's emails, photos of my damaged door, copies of the state law, and Thomas's letter with Patricia's responses. While we waited for the AG's office to respond, which Thomas warned could take weeks, he suggested I also reach out to the State Highway Department for an official confirmation that my snow removal practices were legal. This would create an additional paper trail and give us ammunition if this ended up in court. I called the Massachusetts Department of Transportation on Monday morning and was transferred 3 times before reaching someone in the Highway Division who actually understood my question. His name was Robert Chen, and he was a district maintenance supervisor. "Let me make sure I understand," Robert said after I explained the situation. "Your HOA is fining you for plowing snow from your private driveway into a town-maintained residential street, correct? And you are not creating a hazard, not blocking the road or pushing snow onto other people's property?" "No. I pile it on the edge of my property line along the street, just like everyone else does. The town plows redistribute it when they come through." Robert laughed. It was not a polite chuckle. It was a full, genuine laugh of disbelief. "That is the most ridiculous thing I have heard this week, and I deal with politicians. Hold on." I heard typing in the background and papers rustling. "Okay," Robert came back on the line. "I am going to send you an official letter on state letterhead confirming that your snow removal practices are not only legal, but are consistent with state guidelines and best practices. You are not depositing snow on a state highway. You are not creating a hazard. You are doing exactly what millions of Massachusetts residents do every winter. Your HOA has no authority to fine you for this, and their bylaw attempting to restrict this practice is likely unenforceable as it conflicts with state transportation policy." "Really? You can do that?" "Absolutely. This is part of my job. We deal with snow removal questions all winter long. Usually it is municipalities asking about liability or contractors wanting clarification on regulations. But yes, I can and will provide you with written confirmation. Give me your email address." I gave him my email and thanked him profusely. He said the letter would be sent within 2 business days and that I should contact him if I needed anything else. When I hung up, I felt actual hope for the first time since finding that initial citation. I had the law on my side. I had a lawyer helping me. And now I was going to have official confirmation from the State Highway Department that I was right. Patricia Harmon had picked the wrong person to bully. The State Highway Department letter arrived via email exactly 2 business days later, just as Robert had promised. It was beautifully official, with the state seal at the top and Robert's title and credentials listed below his signature. The letter was addressed to me but written in a way that could be presented to any third party, including an HOA or a court. It stated clearly that depositing snow from private property onto adjacent public roads was standard practice in Massachusetts, that it was explicitly permitted under state transportation guidelines, and that HOAs did not have the authority to prohibit practices that were consistent with state law and public safety standards. Robert had even included a paragraph noting that attempting to prevent proper snow removal could actually create liability for the HOA if residents were unable to safely maintain their driveways, and someone got injured. I printed 5 copies and emailed the PDF to Thomas, who responded with 3 thumbs-up emojis and the message, "She is done." I hand-delivered a copy to Patricia's house the next morning. She lived in one of the larger homes in Meadowbrook Heights, a sprawling colonial with professional landscaping that must have cost more to maintain than my car payment. Her silver Mercedes SUV was in the driveway, so I knew she was home. I rang the doorbell and waited. It took almost 3 minutes for her to answer, and when she did, her expression was already set in disapproval. Patricia was in her early 50s, with blonde hair cut in that aggressive bob that seemed to be required for women in HOA leadership positions. She was wearing athleisure clothing that probably cost more than my entire wardrobe, and her makeup was flawless despite it being 8 in the morning on a Saturday. "Connor," she said, not bothering to hide her disdain, "this is inappropriate. HOA business should be conducted through proper channels." "This is proper channels," I said, holding out the letter from the state. "This is official confirmation from the Massachusetts Department of Transportation that my snow removal practices are completely legal and that your fine is invalid." She took the letter, barely glancing at it. "The state's opinion on general practices does not override our contractual agreements. The bylaws are clear." "The bylaws cannot contradict state law, Patricia. You know that. Any lawyer knows that." Thomas explained it in detail in his letter. "Thomas Brennan is not a neutral party. He lives in this community and has his own grievances with the board." "Then get your own lawyer. Have them read the state law. Have them read this letter. You are wrong and you need to withdraw the fine before this gets worse." Patricia's expression hardened. "The fine stands. If you refuse to pay, we will proceed with placing a lien on your property as outlined in the bylaws. This conversation is over." She tried to close the door, but I put my hand against it, not forcefully, just enough to keep it from shutting. "I have filed a complaint with the state attorney general's office," I said. "I have documentation of everything, including you damaging my property to deliver an invalid fine. You are opening yourself and the board to serious liability. Just withdraw the fine and we can all move on." For a moment, something flickered across her face. Uncertainty, maybe. But it was gone as quickly as it appeared, replaced by cold determination. "Remove your hand from my door or I will call the police and report you for harassment and trespassing." I stepped back, holding up both hands. "Fine. But you have been warned. When the AG's office comes after you, when you end up paying legal fees and penalties, remember that I tried to give you an out." I walked back to my car, leaving her standing in her doorway with the state letter in her hand. As I pulled away, I saw her look down at the letter, actually reading it this time. Maybe something would get through to her, but I was not holding my breath. The next HOA board meeting was scheduled for the following Thursday evening. These meetings were technically open to all residents, though usually only 10 or 15 people showed up out of the 200 homes in Meadowbrook Heights. Most people did not care about HOA politics until the HOA did something to directly affect them. I planned to change that. David and I spent the week going door to door in the neighborhood, telling people about what happened and inviting them to the meeting. We focused on people who had been fined for minor violations in the past or who had complained about Patricia's leadership. We found a lot of them. There was Margaret Sullivan, who had been fined $300 because her mailbox was painted forest green instead of hunter green. The HOA bylaws specified hunter green, but the paint store had been out of it, and she had thought forest green was close enough. Patricia disagreed. There was James and Linda Porter, who had been cited for having their trash cans visible from the street for more than 2 hours before collection time. They had put them out at 6 in the morning before leaving for work. Collection was at 9. Patricia had driven through the neighborhood at 7:30 specifically to look for violations. There was Rachel Nguyen, who had been fined for parking her work van in her own driveway overnight. She was a physical therapist who made home visits. The van had her business name on the side. Patricia said it was commercial activity and violated the residential only use provisions. Rachel had to rent a storage unit for the van, costing her $200 a month. The stories went on and on. By the time Thursday rolled around, David and I had personally invited 47 people to the meeting, and word had spread to others. When we arrived at the community center where meetings were held, the parking lot was already packed. The community center was a small building at the edge of our development, paid for by HOA dues and used for meetings, holiday parties, and the occasional resident social event. It had one main room with a small stage at one end and folding chairs that were usually set up in neat rows. Tonight, there were not enough chairs. Over 100 people had showed up. Patricia was already on the stage with the other 4 board members. Denise Carmichael, the treasurer, Frank Morrison, the secretary, Susan Goldstein, and Harold Chen, members at large. They all looked shocked at the turnout. Board meetings usually had maybe a dozen residents scattered among 50 empty chairs. Tonight, people were standing along the walls, sitting on the floor, and more were trying to squeeze in through the door. Patricia called the meeting to order at 7 p.m. sharp, banging her gavel like she was a judge and not a woman on a power trip in a suburban HOA. She tried to start with the usual routine: reading minutes from the last meeting, financial reports, landscape committee updates. "Point of order," I called out from the third row. I had positioned myself near the front but not in the first row. First row seemed too aggressive. Third row was strategic. Patricia's eyes narrowed. "There is no point of order. We have not opened the floor for resident comments yet." "Actually," Thomas stood up from where he was sitting near the back. "According to the HOA bylaws, Section 3.14, any resident can raise a point of order at any time during the meeting if it pertains to the conduct of the board. Connor, what is your point of order?" I stood up, holding my folder with all my documentation. "My point of order is that the board is currently enforcing an invalid bylaw that contradicts state law, and that board members may be exposing themselves to personal liability by continuing to do so." The room erupted. Everyone started talking at once. People were standing up, some agreeing with me, others confused, a few angry. Patricia banged her gavel repeatedly. "Order, we will have order." It took a full 2 minutes for the room to quiet down. "Connor Stanton," Patricia said, her voice dripping with condescension, "you do not have the floor. You are out of order." "He raised a valid point of order," Thomas countered. "Under Robert's Rules of Order, which the bylaws state govern our meetings, points of order take precedence over other business." Patricia looked at Frank, the secretary, who was frantically flipping through a copy of Robert's Rules of Order. He looked up and nodded reluctantly. "Fine," Patricia said. "State your point and sit down. The board recently passed a bylaw prohibiting residents from depositing snow into the street. This bylaw contradicts Massachusetts state law, which explicitly permits this practice. The State Department of Transportation has confirmed in writing that my snow removal practices are legal and appropriate. Yet the board has fined me $1,000 and threatened to place a lien on my property. This is not only wrong, it is potentially illegal harassment." I pulled out copies of the state letter and the relevant statutes and held them up. "I have documentation from the State Highway Department, from state law, and from municipal guidelines. All confirm that what I did was legal. The HOA cannot enforce a rule that contradicts state law. I am requesting that the board immediately rescind the fine and withdraw the invalid bylaw. The room erupted again, this time louder. I saw heads nodding all over. Several people were on their phones, probably looking up what I had just said to verify it. David was grinning. Margaret Sullivan was literally clapping. Patricia was red-faced. The bylaws are contractual obligations. Every resident agreed to them when they purchased property here. We have the right to enforce standards that go beyond state minimums. Not when those standards contradict state law, Thomas called out. Permissive state laws cannot be restricted by private contracts when they pertain to public safety and property maintenance. This is settled law. Are you representing Connor? Patricia demanded. I am speaking as a resident and an attorney, and I am warning the board that continuing to pursue this fine exposes you to liability. Denise, the treasurer, leaned over and whispered something to Patricia. Susan and Harold were having a hushed conversation. Frank looked miserable. Patricia banged the gavel again. We will take your complaint under advisement. The board will discuss this matter in executive session and provide a response in writing within 30 days as required by the bylaws. 30 days, I said. The fine is due in 16 days. You are going to keep threatening me with a lien while you take 30 days to discuss whether you were wrong. That is the process, Patricia said firmly. Meeting adjourned. We have not covered half the agenda, Harold pointed out. I am adjourning the meeting, Patricia repeated. This is clearly not a productive environment. She stood up and walked off the stage, followed by a flustered Frank. Denise, Susan, and Harold stayed behind, looking uncomfortable as over 100 residents began shouting questions and complaints at them. Thomas made his way through the crowd to me. She is panicking. That was not how a confident board president acts. She knows she is wrong. So what happens now? We wait a few days. If she does not withdraw the fine voluntarily, I will file an injunction to prevent her from placing the lien. That will force a court hearing, and I guarantee you the judge will not be sympathetic to the HOA's position. Meanwhile, the AG's office is probably going to start their investigation soon. You filed the complaint 2 weeks ago, and these things usually take 4 to 6 weeks to get assigned. Over the next hour, I must have talked to 50 different residents. Everyone had a story about Patricia or the board. Everyone was frustrated. Several people asked if we could recall the board or vote Patricia out. Thomas explained that according to the bylaws, board elections were annual and held in November, which was 9 months away. Recall provisions required a petition signed by 60% of homeowners, and then a special election, which was a huge organizational challenge. But, Thomas said to the group that had gathered around us, if the state AG finds that the board has been violating state law or engaging in harassment, they can impose sanctions, require new elections, or even dissolve the board temporarily. So the complaint Connor filed could actually trigger bigger changes than a recall effort. People liked that idea. I exchanged phone numbers and email addresses with dozens of residents who wanted to stay informed. By the time I left the community center at 9:30, I felt exhausted but validated. I was not alone in this. Patricia had made a lot of enemies, and they were all ready to push back. The next morning, I woke up to discover that someone had spray-painted HOA Tyrant in large red letters across Patricia's garage door. I only knew about it because David called me at 7 a.m. Turn on the local news. Channel 5. I stumbled out of bed, fed Murphy, and turned on the TV. The local morning news was covering a story about vandalism in Ashford. The camera showed Patricia's house, specifically her garage, which was now decorated with the spray-painted message. Patricia herself was being interviewed, standing in her driveway in what looked like the same athleisure outfit from last week. "This is what happens when people disagree with common-sense rules," Patricia was saying to the reporter. "The HOA exists to maintain property values and community standards. Some residents refuse to accept any authority, and now they have resorted to vandalism and harassment." The reporter, a young woman with dark hair pulled back in a professional bun, nodded sympathetically. "Do you have any idea who might have done this?" "I have suspicions," Patricia said, looking directly at the camera. "There is a small group of residents who have been increasingly hostile toward the board. They disrupted our meeting last night with false claims about bylaws and state law. Now this. I have contacted the police and I expect a full investigation." My phone rang. It was Thomas. "Please tell me you did not vandalize her house," he said without preamble. "What? No, of course not. I just saw it on the news." "Good. Because that is exactly what she is going to try to claim." "Do you have an alibi for last night after the meeting?" "I went home. I was alone." "Well, Murphy was there, but I do not think my dog counts as an alibi." "Did you make any calls? Order food? Anything that would put you at home at a specific time?" "I thought about it. I ordered Thai food around 10 p.m. It was delivered at 10:30. I have the receipt in my email." "Perfect. Forward it to me. Also, do you have security cameras?" "No." "Get some. Today. Patricia is escalating and you need to protect yourself." After hanging up with Thomas, I sat on my couch and processed what was happening. Someone had vandalized Patricia's house. It was not me, but the timing was incredibly suspicious, coming just hours after a contentious board meeting where I had publicly challenged her. Of course she was going to suspect me or blame me, whether she actually believed I did it or not. The doorbell rang at 8:30. I looked through the peephole and saw 2 Ashford police officers standing on my porch. I took a deep breath, checked that I was at least wearing presentable clothes, and opened the door. "Connor Stanton?" the older officer asked. He was in his late 40s with graying hair and a weathered face that suggested he had been doing this job for a long time. "That's me." "I am Officer Davis. This is Officer Ramirez. We need to ask you some questions about an incident that occurred last night. May we come in?" "Am I being accused of something?" "We just want to ask some questions," Officer Ramirez said. She was younger, maybe early 30s, with sharp eyes that were currently assessing me. "Give me 1 second. I pulled out my phone and texted Thomas. "Police are here asking about vandalism." "What do I do?" His response came back in seconds. "Be polite and cooperative. Answer their questions. You have an alibi. Do not volunteer information they do not ask for. I can be there in 20 minutes if needed." I put the phone away and stepped aside. "Come in." We sat in my living room. Murphy immediately went to investigate the officers, tail wagging. Officer Davis petted him absently while Officer Ramirez pulled out a notepad. "Were you at the HOA board meeting last night at Meadowbrook Heights?" Davis asked. "Yes." "What time did you leave?" "Around 9:30, maybe 9:40. "Where did you go after the meeting?" "I came home." "Can anyone confirm that?" "I ordered Thai food that was delivered at 10:30. I have the receipt and the delivery driver's information." Officer Ramirez made a note. "Did you leave your house at any point after coming home last night?" "No." "I ate dinner, watched TV, and went to bed around midnight." "Do you own any spray paint?" Officer Davis asked. "No." "Have you had any conflicts with Patricia Harmon?" This was the tricky question. I could not lie to the police, but I also did not want to make myself sound like a vengeful neighbor. "I have a dispute with the HOA board regarding a fine they issued me. It is a legal matter. My attorney is handling it. What kind of fine? They fined me for plowing snow from my driveway into the street, which is a standard practice and is legal under state law. I am challenging the fine. Were you angry about this dispute last night? I considered the question. I was frustrated with the situation, but I would not say I was angry. I presented my case at the meeting with documentation. My attorney was there. We are handling this through proper legal channels. The officers asked a few more questions about my relationship with Patricia, whether I knew of anyone who might have vandalized her property, and whether I had seen anything suspicious the previous night. I answered everything honestly and directly. When they stood to leave, Officer Davis handed me his card. If you think of anything else, give us a call. Also, for what it is worth, I have lived in an HOA neighborhood, I get it, but vandalism is never the answer. I agree completely, I said. I hope you find whoever did it. After they left, I immediately called Thomas and told him about the conversation. You did fine, he said. They have nothing on you because you did not do it. Patricia was probably hoping they would find paint in your garage or something, but obviously they did not ask to search because they do not have probable cause. This will blow over. But it did not blow over. That afternoon, I received an email from Patricia in her capacity as HOA president. It was sent to my email address and CC'd to the entire board. The subject line was additional violations and increased penalties. The email stated that due to ongoing harassment of board members, disruption of official meetings, and suspected criminal activity, my fine was being increased to $2,000, and the grace period for payment was being reduced to 7 days. If I did not pay within 7 days, the board would place a lien on my property and pursue legal action for the full amount plus attorney's fees. I read the email 3 times, my hands shaking with anger. This was pure retaliation. She had no evidence I vandalized her house. The police had not accused me of anything, but she was using her position on the HOA board to punish me anyway. I forwarded the email to Thomas with a simple message. Now what? His response was immediate. Now we go to court. I am filing the injunction tomorrow morning. This is so far over the line that I am honestly shocked. Print out that email. It is evidence of retaliation and abuse of authority. That evening, David came over with a 6-pack of beer. We sat in my living room and I filled him in on everything that had happened. I am sorry, man, David said. This has gotten really out of control. I just wanted her to withdraw an invalid fine, I said. I did not want to become the neighborhood pariah or get accused of vandalism or end up in court. You are not the pariah. Patricia is. Everyone I have talked to is on your side. People are actually organizing a petition to recall the board. Thomas said that would be hard to do. Sure, but people are mad enough to try. Margaret Sullivan is leading it. She has been going door to door getting signatures. Last I heard, she had over 60 people signed up. That was 60 out of 200 households, which meant they were about a third of the way to the 60% threshold needed. It was more support than I expected. My phone buzzed with a new email. It was from an address I did not recognize. Mass AG Inquiry at State Moss. I opened it. It was from the Massachusetts Attorney General's Office, Consumer Protection Division. They were writing to inform me that my complaint had been assigned to an investigator named Sarah Mitchell. She would be contacting me within the next week to discuss the matter and gather additional information. The email also noted that they had sent a preliminary inquiry letter to the HOA board informing them of the complaint and requesting documentation of their bylaws, meeting minutes, and enforcement actions. I showed the email to David. Things are about to get interesting. Thomas filed the injunction on Friday morning. By Friday afternoon, we had a court date scheduled for the following Wednesday. The judge had granted a temporary restraining order preventing the HOA from taking any action to place a lien on my property until the hearing. Patricia sent an email to all residents that evening claiming that certain individuals were using frivolous lawsuits to harass the board and waste HOA resources on legal fees. She reminded everyone that those legal fees came from dues paid by all residents. The implication was clear. If the HOA had to spend money defending itself, it was my fault, and everyone's dues would go up. Several residents forwarded me her email along with messages of support. A few people replied all to Patricia's email with their own messages disagreeing with the board's actions. One resident, a retired engineer named George Patterson, wrote a point-by-point rebuttal explaining why the snow removal bylaw was illogical and unenforceable. The neighborhood was taking sides, and it seemed like most people were not on Patricia's side. On Monday, I got a call from Sarah Mitchell, the AG investigator. She was professional and thorough, asking detailed questions about the timeline of events, the fines, Patricia's responses, and the retaliation. I sent her copies of everything: the original citation, the State Highway Department letter, Thomas's legal correspondence, Patricia's emails increasing the fine, and the spray paint incident and subsequent police visit. "This is a pretty clear-cut case," Sarah said after reviewing everything. HOA boards have authority, but they cannot enforce rules that contradict state law, and they certainly cannot retaliate against residents who challenge their decisions through proper channels. I will need to interview the board members and review their documentation, but based on what you have provided, I expect we will be taking action. What kind of action? That depends on what else we find. At minimum, they will be required to rescind the invalid bylaw and refund your fine with interest. If we find a pattern of abuse or retaliation, we can impose penalties, require training for board members, or in extreme cases, we can seek to have the board dissolved and force new elections. How long does this process usually take? Months, unfortunately. The court hearing you have scheduled for Wednesday will probably resolve your immediate issue faster than our investigation, but our investigation will address the systemic problems with how this HOA is being run. I thanked her for her time and hung up feeling cautiously optimistic. Between the court hearing and the AG investigation, Patricia's reign of terror might actually be coming to an end. The vandalism investigation took an unexpected turn on Tuesday morning. Officer Ramirez called my cell phone. "Mr. Stanton, I wanted to give you an update. We reviewed security camera footage from several homes on Miss Harmon Street. We have identified a suspect in the spray painting incident. It was not you." "I know it was not me." "Yes, well, I wanted to make sure you knew that we know that." "Officially, the suspect is actually a teenager from the next neighborhood over. He has been involved in several graffiti incidents in the past few months. This does not appear to be related to your HOA dispute at all. Wrong place, wrong time." "Did you tell Patricia?" we informed Miss Harmon this morning. She seemed disappointed, to be honest. I almost laughed. Of course she was disappointed. She had been hoping it was me so she could add criminal charges to her list of grievances. "Thank you for letting me know, officer." "No problem. And Mr. Stanton, between you and me, I grew up in an HOA neighborhood. I remember my parents getting fined because our grass was a quarter-inch too long during a drought. I get where you are coming from. Good luck tomorrow." The court hearing was scheduled for 2 p.m. on Wednesday at the Middlesex County Superior Court in Cambridge. Thomas told me to wear business casual clothing, and to bring all my documentation, even though he already had copies of everything. First impressions mattered, and I needed to look like a reasonable person, not an angry homeowner on a vendetta. We met outside the courthouse at 1:30. Thomas was in a full suit, carrying a leather briefcase that looked expensive. He had been a litigator for 15 years before transitioning to real estate law, and he knew how to present a case. The HOA retained a lawyer, Thomas told me as we walked inside. Guy named Bradford Wells. He is from a firm that specializes in corporate defense. They probably charged the HOA $10,000 just to show up today. Is that good or bad for us? Good. It means they are taking this seriously, which means they know they are in trouble, but it also means they are going to fight. Wells is not going to just roll over and admit his client is wrong. We went through security and made our way to the assigned courtroom. It was smaller than I expected, with maybe 30 seats for observers. Patricia was already there with Bradford Wells, a man in his 60s with silver hair and an expensive-looking suit. Denise and Frank were sitting behind them. None of the other board members had showed up. We sat on the opposite side of the aisle. I tried not to make eye contact with Patricia, but I could feel her glaring at me. At 2 p.m. exactly, the bailiff called the courtroom to order, and Judge Robert Fitzgerald entered. He was in his mid-50s, with a no-nonsense expression that suggested he did not have time for petty disputes. This is a hearing on a motion for preliminary injunction filed by Connor Stanton against the Meadowbrook Heights Homeowners Association, Judge Fitzgerald said, reviewing the file in front of him. I have read the briefs submitted by both parties. Mr. Brennan, you represent the plaintiff. Thomas stood. Yes, Your Honor. And Mr. Wells, you represent the HOA. Wells stood. Yes, Your Honor. Let me make sure I understand the facts. Mr. Stanton plowed snow from his driveway into the street, which is a common practice and is permitted under state law. The HOA fined him for this, claiming it violates a recently amended bylaw. Mr. Stanton challenged the fine, and the HOA increased the fine and threatened to place a lien on his property. Is that accurate? That is an oversimplified version, Your Honor, Wells said. The HOA bylaws establish contractual obligations that residents agree to when purchasing property. The association has the authority to enforce standards that exceed state minimums. Not when those standards contradict state law, Mr. Wells. You are an experienced attorney. You know that. Wells cleared his throat. Your Honor, the state law is permissive, not mandatory. It allows residents to deposit snow in the street, but it does not require municipalities or associations to permit this practice in all circumstances. Except that this is not about permitting the practice, Judge Fitzgerald said. This is about punishing a resident for engaging in a practice that is explicitly legal under state law, and that poses no danger to anyone. Mr. Brennan, your client has documentation from the State Highway Department confirming the legality of his actions. Thomas handed a copy of Robert Chen's letter to the bailiff, who passed it to the judge. Judge Fitzgerald read it quickly. This is pretty clear. The state says this is fine. Why is the HOA interfering? Patricia stood up, which caused her attorney to look alarmed. Your Honor, if I may, you may not, Judge Fitzgerald said firmly. You are represented by counsel. He will speak for you. Sit down. Patricia sat, her face flushed. Wells tried to recover. Your Honor, the HOA's concern is maintaining property values and community standards. Allowing snow to be deposited in the street creates an unsightly appearance and potentially reduces the aesthetic appeal of the neighborhood. So does snow, the judge said dryly. It is winter in Massachusetts, Mr. Wells. Snow happens. Homeowners deal with it. Your client is trying to enforce an aesthetic preference that conflicts with practical necessity and state law. That is not going to fly. Wells tried a different approach. The HOA board has a fiduciary duty to all residents. They passed this bylaw after receiving complaints from several homeowners about snow management. "Do you have documentation of those complaints?" Judge Fitzgerald asked. "I believe the board has records, Your Honor." "You believe? You either have evidence or you do not." The judge looked at Thomas. "Mr. Brennan, does your client have evidence that the bylaw was passed without proper notice or procedure?" Thomas stood again. "Yes, Your Honor. The bylaw was passed 2 months ago during a board meeting. According to the HOA's own bylaws, any amendments must be announced to residents at least 30 days in advance and approved by a majority of homeowners, not just the board. This requirement was not followed." Wells looked uncomfortable. "Your Honor, that is a procedural argument that should be addressed through the HOA's internal dispute resolution process, which requires residents to exhaust all internal remedies before seeking external relief, correct?" Judge Fitzgerald asked. "Yes, Your Honor." "And how long does that process take?" "It can take 60 to 90 days. And in the meantime, your client is threatening to place a lien on Mr. Stanton's property for engaging in legal behavior." "No, we are not doing that." Judge Fitzgerald made a note on his paperwork. "Here is what is going to happen. The preliminary injunction is granted. The HOA is prohibited from placing a lien on Mr. Stanton's property pending resolution of this dispute. The HOA is further prohibited from assessing any additional fines or penalties against Mr. Stanton related to snow removal. The existing fines are suspended." Wells tried to object. "Your Honor, I am not finished, Mr. Wells. Furthermore, I am ordering mediation between the parties. You have 30 days to reach a resolution through a court-appointed mediator. If you cannot resolve this, we will have a full hearing on the merits, and I will make a final determination. But let me be clear. Based on what I have seen today, the HOA's position is weak. Very weak. I strongly suggest your client consider withdrawing this bylaw and refunding Mr. Stanton's fines before this gets more expensive for everyone involved." The judge banged his gavel. "Next case." We stood as the judge exited. I felt like I had just won the lottery. Thomas was grinning. "That went about as well as it possibly could have," he whispered as we gathered our papers. Across the aisle, Wells was having a heated, whispered conversation with Patricia, who looked furious. Denise and Frank just looked defeated. As we walked out of the courtroom, Patricia caught up to us in the hallway. "This is not over," she hissed at me. "You have turned this entire neighborhood against the board, wasted everyone's money on legal fees, and made it impossible for us to enforce any standards. I hope you are happy." "I just wanted you to follow the law," I said calmly. "That is all I ever wanted. You humiliated me. You humiliated yourself by doubling down on something you knew was wrong." Thomas put a hand on my arm, a gentle warning not to escalate, but Patricia was not done. "The AG investigation will find nothing," she said. "The board has done everything by the book. You are going to end up looking like a vindictive troublemaker, and you are going to have to live in this neighborhood with everyone knowing you wasted their money on your personal vendetta." "The only person who wasted money was you," Thomas said. "You hired a corporate defense attorney for a case you were clearly going to lose. That was your decision. Now, if you will excuse us, we have work to do." We walked away, leaving Patricia standing in the courthouse hallway looking like she wanted to explode. The mediation was scheduled for 3 weeks later. In the interim, things in Meadowbrook Heights got worse for Patricia. The recall petition reached the required 60% threshold. Margaret Sullivan, and a team of volunteers had collected signatures from 123 households out of 200. The petition was submitted to the board, which was required by the bylaws to schedule a special election within 45 days. Patricia sent another email to all residents claiming the recall was orchestrated by a small group of malcontents, and that removing the board would leave the neighborhood without leadership during a critical time. She urged people to rescind their signatures, which they had the right to do up until the election was officially called. 3 people rescinded their signatures. 120 remained. The election was scheduled for mid-May. Meanwhile, Sarah Mitchell from the AG's office had completed her preliminary investigation. She contacted me to let me know that they had found multiple violations of Massachusetts consumer protection law and HOA regulations. The board had improperly assessed fines, failed to follow proper amendment procedures for bylaws, and engaged in retaliatory conduct against residents who challenged their decisions. The AG's office was preparing a consent decree that would require the HOA to make substantial changes or face formal legal action. What kind of changes? I asked. New procedures for passing bylaws, including proper notice and resident voting. Mandatory training for board members on legal compliance, refunds for improperly assessed fines going back 2 years, and oversight by our office for the next 3 years to ensure compliance. That sounds serious. It is. Your complaint opened up a bigger investigation. We reviewed complaints from other residents that had been dismissed or ignored. There is a pattern of abuse here. The board, particularly Ms. Harmon, has been operating like a personal fiefdom. That stops now. The mediation session was held at a neutral office in Cambridge. Thomas and I arrived at 9 a.m. Patricia came alone, without her attorney, which surprised us. Bradford Wells had apparently billed the HOA so much for the court hearing that the board had refused to authorize additional legal fees for mediation. The mediator was a retired judge named Alina Park. She was in her 70s, with kind eyes and a firm handshake. She explained the mediation process. Each side would present their position. She would work to find common ground, and ideally, we would reach an agreement that satisfied everyone. Patricia went first. Her presentation was defensive and bitter. She talked about the challenges of managing an HOA, the unappreciative residents who complained about everything, the difficulty of maintaining standards when people refuse to follow rules. She claimed the snow removal bylaw was passed in good faith to address legitimate concerns about neighborhood appearance. When it was my turn, I kept it simple. I explained that I had no problem following reasonable rules, but that this rule was neither reasonable nor legal. I had tried to resolve the issue privately by providing documentation that my actions were lawful. Instead of reconsidering, the board had retaliated by increasing fines and threatening my property. All I wanted was for the fine to be rescinded, the bylaw to be withdrawn, and an acknowledgement that residents had the right to challenge board decisions without fear of retaliation. Alina listened carefully to both presentations and then asked Patricia a simple question. Why did you increase Mr. Stanton's fine after he provided evidence that the bylaw contradicted state law? Patricia hesitated. He was being disrespectful. He disrupted a board meeting and hired a lawyer to threaten us. He exercised his legal rights, Alina said. That is not disrespect, that is due process. And from what I understand, the meeting was disrupted by over 100 residents who were concerned about the board's actions, not just Mr. Stanton. They were stirred up by his campaign against the board, or they were concerned residents who had legitimate grievances. Alina leaned forward. Patricia, I have mediated dozens of HOA disputes, I am going to be frank with you. You are on the wrong side of this. The bylaw is unenforceable. The fine was improper. The retaliation was illegal. You can continue fighting and rack up legal fees and face sanctions from the Attorney General's office, or you can admit the mistake, fix it, and move on. What is it going to be? There was a long silence. I could see Patricia struggling with her pride, her anger, her need to be right. Finally, she spoke. What would the settlement terms be? Eleanor looked at Thomas and me. Thomas pulled out a document we had prepared in advance. The HOA withdraws the snow removal bylaw, Thomas said. All fines assessed against Connor are rescinded and marked as invalid in HOA records. The HOA issues a written acknowledgement that Connor's snow removal practices were lawful. The HOA agrees not to take any retaliatory action against Connor or any other resident who participated in challenging board decisions. And the HOA pays Connor's attorney fees, which currently total $4,000. Patricia's eyes widened. $4,000. That is my discounted rate for a neighbor, Thomas said. If this had gone to a full trial, it would have been triple that. Eleanor looked at Patricia. These terms are reasonable. More than reasonable, actually. Mr. Stanton could ask for damages for the stress and harassment he has endured. He is not. He is simply asking to be made whole and to have his legal fees covered. I recommend you accept. Patricia looked at me, and for the first time I saw something other than anger in her eyes. She looked tired, defeated. Fine, she said quietly. I accept the terms. We spent the next hour working with Eleanor to draft the formal settlement agreement. Patricia signed it. Thomas and I signed it. Eleanor witnessed and notarized it. It was done. As we were packing up to leave, Patricia stopped me at the door. I want you to know something, she said. I was trying to protect the neighborhood. Property values matter. Standards matter. Maybe I went about it the wrong way, but my intentions were good. I thought about all the stress of the past months, the invalid fines, the vandalism accusation, the retaliation, the threats. But I also saw a woman who had invested too much of her identity in a volunteer position and did not know how to back down when she was wrong. I believe your intentions were good, I said, but impact matters more than intentions. A lot of people were hurt by your decisions. I hope the new board does better. New board. The recall election is in 3 weeks. You must have heard. Patricia's face fell. She had clearly been in denial about the election actually happening. I have been on the board for 8 years. I have given so much time to this community. Then you have earned a break, I said. Let someone else take over. I left her standing there and walked out with Thomas. You were diplomatic, Thomas said as we walked to our cars. I would have told her off. She is beaten already, no point kicking her when she is down. The recall election took place on a rainy Saturday in mid-May. Turnout was the highest in Meadowbrook Heights history. Over 70% of households voted. The entire existing board was recalled. Patricia received only 18 votes to remain as president. The new board was elected the same day. Margaret Sullivan became president. David was elected treasurer. 3 other residents I had met during this saga filled the remaining positions. Thomas declined to run, saying he wanted to remain available as legal counsel without a conflict of interest. The new board's first action was to review all HOA bylaws and identify any that conflicted with state or local law. They found 7, including the snow removal rule. All 7 were repealed. They also implemented new procedures for bylaw amendments, requiring 60 days notice, public comment periods, and approval by a majority of homeowners, not just the board. The Attorney General's consent decree was finalized in June. The HOA was required to refund over $12,000 in improperly assessed fines to various residents over the past 2 years. Patricia personally was required to complete a 20-hour training course on HOA governance and Massachusetts consumer protection law. The board was placed under AG oversight for 3 years, with quarterly compliance reports required. Patricia moved out of Meadowbrook Heights in August. I heard through the neighborhood grapevine that she and her husband bought a house in a non-HOA neighborhood in New Hampshire. I hoped she would be happier there. As for me, life went back to normal. I continued plowing my snow into the street every winter, just like everyone else. Murphy and I took our daily walks through the neighborhood, and I got to know more of my neighbors than I ever had before. Shared adversity had built a real community. Margaret turned out to be an excellent HOA president. She ran meetings efficiently, communicated clearly, and actually listened to residents' concerns. Dues were used for neighborhood improvements that people actually wanted, like fixing the playground and repaving the walking trails. Fines were rare and always justified by clear, enforceable rules. 1 year after the whole saga began, David and I were standing in my driveway after a heavy snowstorm, watching the town plows redistribute the snow we had pushed into the street. "Remember when you got fined for this?" David asked, gesturing at the snow piles. "How could I forget? That was the most stressful 3 months of my life. But it was worth it, right? The HOA is actually functional now. Patricia is gone. People are not getting harassed with ridiculous fines." I thought about it. The stress, the anger, the confrontations, the legal fees, the public conflict. Was it worth it? "Yeah," I said. "It was worth it. Sometimes you have to stand up to bullies even when it is hard, especially when it is hard." David nodded. "Want to get a beer?" "Absolutely." We walked inside, leaving our boots by the door, and I felt genuinely grateful. Grateful for good neighbors, for a functional HOA, for state laws that protected homeowners from petty tyrants, and for the simple fact that I could plow my driveway without fear of absurd penalties. Sometimes the system works. Sometimes standing up for what is right actually makes a difference. Sometimes the good guys win. And sometimes, the best revenge is just living well in a neighborhood that finally has its act together. Over the following months, I watched Meadowbrook Heights transform. The new board implemented regular town halls where residents could voice concerns before they became major issues. Bylaws were posted online with plain language explanations. Financial reports were published quarterly, so everyone could see exactly where their dues were going. It felt less like living under a dictatorship and more like being part of an actual community. I stayed involved, attending most board meetings and volunteering for the landscape committee. Not because I particularly enjoyed HOA politics, but because I had learned an important lesson. Unchecked authority always leads to abuse. The only way to prevent another Patricia situation was for engaged residents to stay engaged. Thomas continued to provide pro bono legal advice to the board, helping them navigate complex issues and ensure compliance with state law. He seemed to enjoy it, joking that it was more interesting than reviewing commercial real estate contracts all day. Murphy became something of a neighborhood celebrity. People recognized him from our daily walks and always stopped to say hello. Kids in particular loved him, and I started bringing him to HOA social events, where he would happily accept pets and treats from anyone willing to provide them. The snow removal bylaw became something of a legend in our community, a cautionary tale about HOA overreach that was told to new residents as a warning about the bad old days. I did not love being at the center of that story, but I appreciated that it served a purpose. People remembered what happened when boards stopped serving residents, and started serving their own egos. One evening in late fall, about 18 months after everything started, I was sitting on my porch with a cup of coffee when Margaret walked by with her husband. They were out for an evening stroll and she waved. "Connor, got a minute?" she called out. "Sure, come on up." They climbed the porch steps, and Margaret's husband Bill shook my hand. I had met him a few times at neighborhood events but did not know him well. "I wanted to thank you," Margaret said, "for everything you did last year. I know it was hard, and I know you probably did not want to become the face of a rebellion against Patricia. But if you had not stood up to her, none of us would have. The neighborhood would still be dealing with her nonsense." "I just did not want to pay an invalid fine," I said. "Everything else sort of happened around that." "That is usually how it works," Bill said. "Someone takes a stand on principle and it opens the door for bigger change. We have seen it happen in local politics, business, everywhere. The hardest part is being the first person to say no." We talked for a while about the neighborhood, upcoming projects, and plans for the holiday season. Before they left, Margaret mentioned that the board was considering establishing a legal defense fund for residents who needed to challenge HOA decisions in the future. They wanted to make sure no one was deterred from standing up for their rights, just because they could not afford a lawyer. "That is a great idea," I said. "I was lucky Thomas helped me out. Not everyone has a lawyer neighbor." "Exactly. We are learning from what happened, making sure it does not happen again." After they left, I sat on my porch for a while longer, watching the sun set behind the houses across the street. The air was cool but not cold yet, that perfect autumn temperature where you could be outside comfortably with just a light jacket. I thought about the journey from that first citation on my door to this moment, about anger and frustration transforming into action, about a community coming together to demand better leadership, about the slow, messy process of change. It was not dramatic or glamorous. It was just people doing the right thing, step by step, until things got better. That was how real change usually happened, I supposed. Not in grand gestures or sudden revolutions, but in accumulated small victories that eventually added up to something meaningful. Murphy pushed the front door open with his nose and came to sit beside me, resting his head on my knee. I scratched behind his ears and looked out at the neighborhood I had fought so hard to improve. It was a good place to live. Not perfect, but good, and getting better all the time. That was enough. The first major snow of the new winter came in early December, dumping 8 inches overnight. I woke up early, fed Murphy, and headed outside with my snowblower. The air was crisp and clean, and the neighborhood looked beautiful under its fresh white blanket. I cleared my driveway systematically, pushing the snow into neat piles along the street edge, just like I had done a dozen times before. Just like I would do a dozen times more this winter. Just like millions of people across Massachusetts were doing at that exact moment. David came out to clear his driveway and waved. George Patterson was already out, using a shovel rather than a snowblower. Several other neighbors emerged as the sun rose higher, and we called greetings back and forth as we worked. No one worried about citations. No one feared retaliation. We were just people taking care of our properties in the most practical, efficient, legal way possible. When I finished, I stood in my driveway and looked at the piles of snow lining the street. Tonight or tomorrow, the town plows would come through and redistribute it. The system worked exactly as it was designed to work. I smiled, went inside, made breakfast, and got ready for another normal day in a neighborhood that had finally figured out how to function properly. And that, really, was the happy ending. Not dramatic or exciting, just peaceful and normal. Which, after everything we had been through, was exactly what we all needed.